Hi, I'm David Slonim of Slonim and Lemieux, and today we're going to start our new series called the 4-Minute Lawyer Series, and we'll kick it off with the durable power of attorney. Now, the durable power of attorney is a document that allows somebody to make legal and financial decisions on your behalf. You are going to be appointing that person, and that person is named as an agent who is then able to do such decisions on your behalf. Now, that agent is somebody that typically is allowed to do this as soon as you sign the document in Florida. And that agent used to be called an attorney in fact, and is not related to an attorney per se, but is just somebody that you nominate. Now, in Florida, ever since 2011, there's some changes that have been made in the durable power of attorney document itself, in that it allows anybody who is named in the document to only do the things that are in the four corners of the document. If the power or the right to do such thing on your behalf is not present in the document, then it cannot be done under Florida law under most circumstances. And that includes potentially applying for Medicaid or doing some other types of planning with a document there. And one thing that's really important that I want to stress with a power of attorney is that your agent can only do things on your behalf. They can't do things that are going to be against your interests or rights or something that you would not want to do. So, for example, if you're being exploited, unfortunately, if you are having to go to the bank and give somebody money and you seem to do it on your own volition, then even if there's a power of attorney in place, then that agent can't prevent you from doing that. And that's where a guardianship would be ultimately necessary to remove that sort of right for you to do these things. So, in general, a durable power of attorney is good to allow somebody to augment your capability, and that's where a standard durable power of attorney is different from a springing durable power of attorney, in that it used to be that it would spring into action if there was an incapacity. Now, under Florida law, you have to understand that as soon as you sign that document, then it is active. And so then your agent can do things while you may have capacity, but maybe just be out of the country or otherwise. And so that's something to, of course, be concerned about with who you name. Also, a power of attorney has to have certain new powers that are specifically granted. I call them superpowers. And in the Florida Durable Powers of Attorney, you have to specifically grant certain superpowers to somebody for them to act. Usually, this covers the creating of any trusts or modifications of trusts, or assigning beneficiaries to certain accounts. All these things do require some superpowers to be assigned to the individual, and that usually requires either a signature or a initialing of the document for those particular powers. Again, as I wrap up for the power of attorney, it is not automatic. A spouse doesn't have automatic authority to make decisions on your behalf. You need to have somebody appointed through a written document. Looking forward to seeing you next time on the 4-Minute Lawyer.